Tonight, we examine a case that once commanded national attention and then became part of British legal history. A single investigation, a single verdict, and a legacy that has endured for more than a century. The case of Camille Cecile Holland begins in Clavering, Essex, in the spring of 1899. Clavering was a small rural parish in the northwestern corner of Essex, close to the border with Cambridgeshire and Hertfordshire, a district of flat arable fields, scattered farmsteads, and narrow lanes connecting market towns such as Saffron Walden and Newport. In 1899, this was still recognisably Victorian England, though the reign of Queen Victoria itself had less than 2 years remaining. The countryside around Clavering was given over largely to cereal farming, with a scattering of dairy holdings, and the rhythms of the district were still set by the agricultural calendar rather than by any industrial clock. The nearest substantial town, Saffron Walden, held a market, a corn exchange, and a modest population of tradespeople, but the immediate vicinity of Clavering remained sparsely populated, its cottages and farmhouses connected by unmade roads that could be difficult to pass in wet weather. At the centre of this account stood a farmhouse, then known as Coldham's Farm, a property distinguished by the broad water-filled ditches, or moats, that surrounded its principal buildings, a common defensive feature of older Essex farmsteads dating back centuries, but by the close of the 19th century, serving no purpose beyond drainage and boundary marking. The farmhouse itself was isolated, set back from the nearest lane, screened by hedgerows and a scattering of trees, with outbuildings including a coach house positioned near the bridge that carried the approach across the moat. It was this feature, the encircling water, that would in time give the property its enduring name, Moat Farm, a name it did not carry when it was purchased, but one that would become permanently attached to it through the events of this record. Essex in this period retained a strongly agricultural character, even as parts of the county closer to London had begun to acquire suburban and commuter populations. The district around Clavering had seen little of that change. Farm labourers, small tenant farmers, and a handful of independent landowners made up the bulk of the local population, and a newcomer of apparent means, arriving with capital to purchase a farm outright, would have been a notable, if not unusual, event in a district accustomed to families holding land for generations. It was into this setting, in the closing years of the 19th century, that a woman named Camille Cecile Holland arrived, a woman whose origins lay not in Essex, nor even in England, but many thousands of miles away, on the eastern coast of India. Camille Cecile Holland was born in approximately 1843 at Chandernagore, a small French colonial enclave on the Hooghly River in Bengal, India. Her father was English, a member of a family with roots in Liverpool, and her mother was French, the two having married at Chandernagore in 1836. The particulars of her father's occupation and the family's residence in India during Camille's earliest years are not established in the surviving record, and this account does not attempt to supply them. What is documented is that the Holland family maintained its connections to Liverpool, and that in the course of Camille's childhood or early adulthood, she came to live in England with her aunt, Sarah Ann Holland, her father's sister, who kept a school for girls in the vicinity of Liverpool. Camille remained with her aunt for a period of years, within the household and routine of a girls' school, an environment that would have provided her with the education and social formation typical of a young woman of her class in mid-Victorian England. When her aunt eventually retired from the school, Camille relocated to London, where she established herself in Bayswater, a respectable residential district on the western side of the city, popular among the middle classes for its terraces of substantial townhouses and its proximity to Hyde Park and Kensington Gardens. It was in London that Camille Holland spent the greater part of her adult life, unmarried, without children, and by the account of the record, living independently on private means. Those private means had a specific origin. A relative of the family in India had, at death, left a sum of money to Camille's aunt, Sarah Ann Holland. Upon the aunt's own death, This inheritance passed to Camille. Combined with whatever independent resources Camille had otherwise accumulated, the inheritance left her, by the late 1890s, a woman of considerable financial substance, holding investments and government consols rather than relying on any earned income or family allowance. This financial independence was not typical for a woman of her generation. Marriage in Victorian England remained for most women the principal route to financial security, and an unmarried woman controlling her own capital, answerable to no husband, and following her aunt's death to no immediate family member resident nearby, occupied an unusual position in the social landscape of the period. The surviving record offers little detail concerning Camille Holland's personality or her daily habits during her years in Bayswater. Later writers on the case have frequently characterised her as a reserved and unworldly woman, cautious in most matters yet inexperienced in judging the character of men who sought her company. Such characterizations rest chiefly on the outcome of events rather than on contemporary testimony describing her disposition, and this account does not adopt them as established fact. What can be stated with confidence, because it is documented through the financial and legal record that followed her death, is that Camille Holland was a woman careful with her money, possessed of investments that she monitored and drew upon in an orderly fashion, and that she left no husband, no children, and no immediate household to raise an alarm when her circumstances changed. She had, by the autumn of 1898, reached her mid-50s and had spent the greater part of her adult life managing her own affairs without apparent difficulty or incident. If you find value in histories preserved this way, consider liking the video and subscribing to the channel. Let me know in the comments where you're listening from. What follows begins in London in the autumn of 1898. It was at the Earl's Court Exhibition, a large and popular venue for public entertainment situated in West London, that Camille Holland's settled life in Bayswater came to an intersection with a man who would irrevocably alter its course. The exhibition grounds at Earl's Court in the autumn of 1898 were host to displays, entertainments, and gathering crowds of the kind that brought together Londoners of varied backgrounds who might not otherwise have occasion to meet. It was in this setting that Camille Holland made the acquaintance of a man calling himself Samuel Herbert Dougal, a man then in his early 50s who presented himself to her as a former army officer possessed of independent means. Dougal's courtship of Camille Holland proceeded over the following months. The surviving record does not preserve the particulars of their meetings, correspondence, or the manner in which their acquaintance developed into an arrangement to live together, but it establishes that by the beginning of 1899 the two had determined to set up a household in the countryside, away from London. Camille Holland believed, on the strength of Dougal's presentation of himself, that she was entering into a settled and respectable arrangement with a gentleman of standing. She was, in fact, entering into an arrangement with a man whose actual history included multiple marriages, a documented pattern of defrauding women of their money, and at least one prior conviction related to forgery, none of which was known to her at the time. The capital required to establish this new household was supplied by Camille Holland herself. In the early months of 1899, she and Dougal identified and purchased a farm property, known as Coldham's Farm, near the village of Clavering in Essex, an isolated holding distinguished by the water-filled ditches surrounding its buildings. The purchase was made using Camille's own funds, a fact later established through the examination of her financial affairs, and the property would in time come to be known, on account of its encircling moat, as Moat Farm. The couple did not take up residence immediately upon purchase. Some weeks passed in which arrangements were made for the property before Camille Holland and Samuel Dougal moved into the farmhouse together in the closing weeks of April 1899. Camille Holland engaged the services of a local girl to assist with the household duties at the farm, a young woman who took up her position shortly after the couple's arrival. The household established in those first weeks of residence at Moat Farm followed, by outward appearance, an ordinary domestic pattern, with Camille directing the affairs of the house and Dougal presenting himself to neighbours and tradespeople as the gentleman of the property. Locally, given the unmarried status of the couple, Camille Holland was frequently and incorrectly presumed to be Dougal's wife, referred to by acquaintances and tradesmen as Mrs. Dougal, a misapprehension that the couple did not, so far as the record establishes, take particular steps to correct. This arrangement, newly begun, was to last only a matter of weeks. On the morning of Friday, the 19th of May, 1899, Camille Holland informed the servant girl that she and Dougal intended to travel into Stansted, a market town lying a short distance from Clavering, so that she might purchase items required for the household. This was, by the account preserved in the record, an unremarkable errand of a kind Camille had reason to undertake in the ordinary course of settling a newly occupied farmhouse. Dougal harnessed the trap, and the two departed from Moat Farm together, leaving the servant girl to her duties about the house. Camille Holland was not seen alive again after that departure. The precise circumstances of what followed cannot be reconstructed from the surviving record with certainty, and this account does not attempt to supply detail beyond what is established. What is documented is that at some point on that Friday, in the vicinity of the farm, Camille Holland was shot once in the head at close range. The weapon was a revolver. No witness to the shooting has ever been identified, and no account of the moment itself survives beyond the physical evidence later recovered. The location most consistently associated with the event, in the reconstructions later undertaken by investigators, was the area near the coach house and the bridge crossing the moat, close to the buildings of the farm itself, though the record does not permit a more exact placing of the act than this general vicinity. Dougal returned to Moat Farm that day without Camille Holland. When the servant girl asked after her employer, Dougal told her that Miss Holland had gone away to stay with relatives. This explanation, delivered on the day of the shooting, was the first telling of a story that Dougal would maintain, elaborate upon, and defend for nearly 4 years afterward. He did not report Camille missing. He did not summon assistance. He continued to occupy the farmhouse as though nothing had occurred, and in the days that followed he undertook to conceal what he had done, digging a grave in one of the drainage ditches on the property and burying Camille Holland's body within it. Over the disturbed ground he planted shrubs, among them rhododendrons, arranging the planting in such a way as to make the newly turned earth appear to be nothing more than an ordinary piece of garden cultivation. The servant girl, given no reason at the time to doubt her employer's account, accepted the explanation that Miss Holland had gone to relatives. In the weeks that followed, Dougal continued to present himself to the district as the master of Moat Farm, a widower or bachelor of property whose companion had simply left for a visit elsewhere. Tradesmen calling at the farm, neighbours passing on the lane, and those with whom Dougal continued to conduct business, had no cause, in the absence of any contrary information, to question this account. Essex in 1899 was a county of scattered rural households, where the comings and goings of a household's members were not subject to any formal registration or oversight beyond what neighbours themselves might observe, and an isolated farm such as Moat Farm, screened by its hedges and its moat, offered Dougal a degree of privacy that made his story easier to sustain than it might have been in a more closely settled community. In the months that followed Camille Holland's disappearance, Dougal began to draw upon her financial resources. Camille Holland had, prior to her death, maintained accounts and financial instruments in her own name, the product of her inheritance and her own careful management over decades of independent life. Dougal, in her absence, began forging her signature, presenting cheques and instructions to bankers and tradesmen as though they carried Camille's own authority. He used these funds to sustain his occupation of Moat Farm and his manner of life there, continuing in this course not for weeks or months, but for a period that would eventually stretch to nearly 4 years. Throughout this period, Camille Holland's own relatives, who had not had direct word from her since May of 1899, remained unaware of what had become of her, and no formal alarm was raised. The scale of this deception, sustained over so long a period, depended upon the limited means by which a signature or a financial instrument could be verified in the England of that period. A banker or tradesman presented with a cheque bearing a familiar name, drawn upon an account known to be genuine, had little occasion or mechanism to question its authenticity, particularly when the account holder was known to reside at a distance and to conduct her affairs, as Camille Holland had for years, in an orderly and unremarkable fashion. Dougal's forgeries were not, by later account, especially sophisticated, but they did not need to be, operating as they did within a system that placed considerable trust in the outward appearance of order and respectability, and within a rural community in which a gentleman of apparent means was not lightly questioned. Concern over the whereabouts of Camille Holland did not begin to surface until the early months of 1903. It was at this point that questions arose, not initially framed around any suspicion of violence, but around the financial instruments being presented in Camille Holland's name, instruments that drew the attention of those handling her affairs and prompted inquiry into their authenticity. It became apparent, as these questions were pursued, that Camille Holland's relatives had not been in direct communication with her in nearly 4 years, a gap of time that, once identified, could no longer be reconciled with Dougal's account that she had simply gone away to stay with family. These financial irregularities, rather than any direct report of a missing woman, were what first drew official attention to the affairs of Moat Farm, and it was through the pursuit of a matter of forgery that the far graver question of Camille Holland's fate began, in the spring of 1903, to be examined in earnest. The inquiry into the forged financial instruments drew the attention of the Essex Constabulary, and by the spring of 1903, the investigation had moved beyond a matter of paper and signatures into a formal examination of Samuel Dougal's conduct and of the fate of Camille Holland herself. Officers were dispatched to make inquiries in the vicinity of Clavering, taking statements from those who had had dealings with Dougal and with the household at Moat Farm over the preceding 4 years. The servant girl who had been told on that Friday in May of 1899 that Miss Holland had gone away to relatives was among those whose recollection of events was sought and recorded, her account establishing the date and the substance of the explanation Dougal had first offered. Tradesmen and neighbours in the district were questioned as to their dealings with Dougal and with the household, and their statements, taken together, established a consistent pattern that Camille Holland had not been seen in the vicinity of Clavering since the days immediately following the couple's arrival at Moat Farm in the spring of 1899. Bankers and others who had handled the financial instruments bearing Camille Holland's signature were also questioned, and their evidence began to substantiate the suspicion that these signatures were not genuine, but had been produced by Dougal himself in the years following her disappearance. It was this convergence of testimony, financial records, and the absence of any confirmed sighting or communication from Camille Holland over so extended a period that led investigators to conclude that a more thorough examination of the Moat Farm property itself was warranted. The decision was taken to search the grounds of Moat Farm directly, and in April of 1903, officers of the Essex Constabulary began a systematic examination of the property, concentrating their efforts upon the ditches and moat that gave the farm its name and its distinguishing character. This was not a task completed in a single day. The digging extended across a period of several weeks, officers working through the wet Essex ground, examining the drainage ditches and the disturbed earth found within them, in a search that required patience and sustained physical labour given the scale of the grounds to be covered, and the uncertainty as to precisely where within them any remains might be concealed. It was in the course of this extended search that officers came upon ground within one of the drainage ditches, bearing signs of having been disturbed and subsequently planted over, an area where shrubs, among them rhododendrons, had been set into the earth in a manner that, upon closer examination, appeared inconsistent with ordinary garden cultivation. Digging beneath this planted ground, officers recovered human remains, buried within the ditch on the 27th of April, 1903. The remains had lain in that ditch for very nearly 4 years, from the time of the burial in May of 1899 to their recovery in the spring of 1903, and the condition in which they were found reflected the length of that interval. The recovery of the remains transformed the character of the investigation entirely, moving it from a matter of forgery and financial impropriety to one of suspected murder. Samuel Dougal, who had by this stage already come under suspicion and scrutiny in connection with the forgery allegations, was taken into custody, and in light of the discovery at the farm, the charge against him was elevated to one of murder. The investigation that had begun with questions over a signature on a cheque had, over the course of a few weeks in the spring of 1903, arrived at the recovery of the woman whose absence had first prompted those questions, buried within sight of the house in which she had lived for only a matter of weeks before her death. Following the recovery of the remains from the ditch at Moat Farm, arrangements were made for a medical examination to determine, so far as the condition of the remains permitted, the cause of death. Given the length of time the remains had lain buried, very nearly 4 years, the examination available to the medical officers was necessarily limited to what could be established from the skeletal evidence and from any trace of injury preserved within it, rather than from the soft tissue examination that would have been possible had the death been more recent. The examination established that the cause of death was a bullet wound to the head, a finding consistent with a single gunshot delivered at close range, and a bullet associated with the injury was recovered in the course of the examination. The severity of the injury was such that death would have followed rapidly, and the medical findings gave no indication of any cause of death other than the gunshot wound identified. The identity of the remains was established through a combination of the location in which they were found, the period of time consistent with Camille Holland's disappearance, and the effects and items of clothing recovered in association with the burial, which were examined and connected to items known to have belonged to her. Taken together with the circumstantial evidence gathered over the preceding weeks of inquiry, these findings permitted investigators, and, subsequently, the coroner's proceedings, to conclude with confidence that the remains recovered from the ditch at Moat Farm were those of Camille Cecile Holland. The medical examination did not extend to a detailed reconstruction of the precise sequence of injury beyond the identification of the fatal wound. The condition of the remains, after nearly 4 years' burial, permitting no further finding of the kind that might have been available in a case examined more promptly after death. Following the medical examination, an inquest was convened before the coroner to inquire formally into the death of Camille Cecile Holland. The inquest heard evidence establishing the identity of the remains, the circumstances of their discovery within the ditch at Moat Farm, and the medical findings as to the cause of death, the bullet wound to the head. Witnesses who had given statements to the investigating officers, including those who had known Camille Holland in the district and those who had handled the financial instruments bearing her forged signature, gave their evidence before the coroner in turn, building before the inquest a picture consistent with that which the police investigation had already established. The proceedings before the coroner concluded with findings sufficient to support the charge already laid against Samuel Dougal, and the matter was referred forward to committal proceedings, with Dougal committed for trial on the 22nd of June, 1903. The trial of Samuel Herbert Dougal opened on Monday, the 22nd of June, 1903, at the Shire Hall in Chelmsford, the seat of the Essex Assizes. The Shire Hall was a Georgian civic building of some architectural distinction, standing at the centre of Chelmsford, and it was within its courtroom that the proceedings against Dougal were conducted before Mr. Justice Wright. The indictment charged that Samuel Herbert Dougal, on the 19th of May 1899, did feloniously, wilfully, and of his malice aforethought, kill and murder Camille Cecile Holland at Clavering, a formulation of the charge that reflected the standard legal language of wilful murder as applied within the English courts of the period. The proceedings before Mr. Justice Wright extended across several days, during which the prosecution set before the jury the accumulated evidence of the investigation, the testimony of witnesses from the districts surrounding Moat Farm, the financial records establishing the pattern of forgery sustained over nearly 4 years, and the medical findings arising from the examination of the remains recovered from the ditch. The case presented to the jury rested upon the convergence of these several lines of evidence. The last confirmed sighting of Camille Holland on the day of the shopping excursion to Stansted, the explanation Dougal had offered and maintained in the years that followed, the discovery of the burial beneath the planted shrubs, and the medical establishment of a fatal gunshot wound, taken together as forming a coherent account of the events of May 1899 and of the years of concealment that followed. The trial proceeded through the examination of witnesses and the presentation of evidence over the course of the assize sitting, the jury hearing testimony, bearing upon each stage of the case, from Camille Holland's arrival in the district with Dougal in the spring of 1899, through the years in which her financial affairs were administered fraudulently in her name, to the search of the farm grounds and the recovery of her remains in April of 1903. The proceedings maintained throughout the formal character typical of a capital trial, conducted at the assizes, with the court adjourning and resuming across the several days required to hear the full body of evidence gathered by the investigation. At the conclusion of the evidence, the jury retired to consider its verdict. Upon its return, the jury delivered a unanimous verdict of guilty against Samuel Herbert Dougal, the verdict being returned on the 23rd of June, 1903. Mr. Justice Wright, following the return of the verdict, proceeded immediately to sentencing, pronouncing upon Dougal the sentence prescribed by law for the crime of wilful murder, that he be taken from the place whence he came, and thence to a place of execution, and there be hanged by the neck until he was dead. The sentence of death was entered upon the record of the Essex assizes on that date, bringing to a close a trial that had drawn considerable attention, both within the county and through the press coverage the case attracted nationally, well beyond it. The case had, by the time of the trial, already become a matter of significant public interest, owing to the length of time that had elapsed between Camille Holland's death and the discovery of her remains, and to the scale of the deception Dougal had sustained across nearly 4 years through the forgery of her signature. Newspapers reporting on the proceedings at Chelmsford characterised the case under headlines referring to the Moat Farm mystery or the Moat Farm murder, terms that reflected the prolonged uncertainty that had surrounded Camille Holland's fate before the search of the farm grounds resolved it. The surviving record does not preserve the names of the counsel who conducted the prosecution or the defence at the trial, nor does it preserve a full account of the cross-examination of individual witnesses beyond the substance of the case as outlined above, and this account does not attempt to supply detail not established by the sources available. No record has been found of any appeal lodged against the verdict or the sentence, nor of any petition for clemency directed to the Home Secretary in the weeks following the trial. The sentence of death, entered on the 23rd of June, 1903, stood without recorded challenge in the period that followed, and preparations proceeded, in the ordinary course of such matters, toward its carrying out at Chelmsford Prison. Samuel Herbert Dougal was executed at Chelmsford Prison at 8 o'clock in the morning on Tuesday, the 14th of July, 1903, 3 weeks after the jury at Chelmsford Assizes had returned its verdict. The execution was carried out by William Billington, who served in the period as one of the public executioners engaged by the prison authorities to conduct hangings at institutions across England. Billington had, by 1903, conducted numerous executions in the course of his duties, and the procedure followed at Chelmsford Prison on that July morning followed the established form observed at English executions of the period, conducted within the walls of the prison rather than in public, in accordance with the practice that had governed capital punishment in England since 1868. In the moments preceding the execution, Dougal is reported, according to multiple contemporary accounts, to have made a form of confession, understood by those present to amount to an acknowledgement of his guilt in the killing of Camille Holland. This detail was widely reported in the press coverage that followed the execution, though it survives as an orally reported account of a single brief moment rather than as any written or formally recorded statement, and it is presented here with that qualification. Following the execution, Dougal was buried within the grounds of Chelmsford Prison, in keeping with the standard practice of the period, under which those executed for capital crimes were interred within the precincts of the prison in which sentence had been carried out, rather than returned to their families for burial elsewhere. The man executed that morning at Chelmsford had, before his acquaintance with Camille Holland, followed a course of life that later inquiry would establish as a long pattern of deception directed toward women and toward those who trusted him. Samuel Herbert Dougal had been born in Bow in the East End of London on the 15th of May 1847. As a young man he enlisted in the Royal Engineers, a corps of the British Army responsible among other duties for survey and mapping work, and he served for a period that included work connected with the Ordnance Survey. His military service extended over many years, and in 1827 he was transferred to Halifax in Nova Scotia, where he extended his engagement with the Royal Engineers to a term of 21 years. Dougal had married in 1869 at Mould in Flintshire, a woman named Lavinia Martha Griffiths. The marriage endured through the years of his military service, including the period of his posting to Nova Scotia, until June of 1885, when Martha Dougal died suddenly, without any prior illness having been recorded. No prosecution followed her death, and no exhumation was undertaken at the time or subsequently to examine its cause more closely, and this account records the death only as it stands in the historical record, a sudden and unexplained death that has since been regarded by researchers of the case as suspicious, without that suspicion ever having been tested in a court of law. 2 months after Martha Dougal's death, in August of 1885, Samuel Dougal married again, to a young Irish woman named Mary Herberta Boyd, who at the time of the marriage already had a child. This second marriage proved shorter than the first. Mary Dougal died in October of 1885, within 2 months of the wedding, her death, like that of Martha before her, sudden and without any prior illness recorded. As with the death of his first wife, no prosecution followed, and no examination beyond what was conducted at the time has been recorded in the sources available. 2 wives, dead within a span of 5 months of each other, in circumstances that later scrutiny would regard as troubling, yet neither death was, in the years immediately following, treated as a matter requiring criminal inquiry. Dougal was discharged from the Royal Engineers in March of 1887, bringing to a close a military career that had spanned some 2 decades. He subsequently took up residence on the Isle of Wight, where he entered into a relationship with a widow named Marion Payne, with whom he had several children born outside of marriage. In 1889, together with Marion Payne, Dougal acquired the goodwill and furnishings of a public house, the Royston Crow, on Baldock Street in the town of Ware, in Hertfordshire, an establishment he operated for a period in the years that followed. In 1892, Dougal married a third time to Sarah Henrietta White, a 20-year-old Irish woman, considerably his junior. It was around this period that Dougal's pattern of financially exploiting women who trusted him became more pronounced and more sustained. He persuaded a woman named Emily Booty to live with him as though she were his wife, drawing upon her financial resources over a period of time before bringing his actual wife to live within the same household, an arrangement that humiliated Emily Booty and that formed part of the broader pattern of conduct later associated with Dougal's name. He moved between several such arrangements in the years that followed, sustaining himself through the resources of women he deceived, and in the course of this period he was convicted on a separate matter involving theft and the forgery of cheques, a conviction that, though the full particulars of its date and sentence are not preserved in the sources consulted for this account, establishes that Dougal's practice of forgery predated his acquaintance with Camille Holland by a number of years. By the time Dougal presented himself to Camille Holland at the Earl's Court exhibition in the autumn of 1898, he was, by this accumulated history, a practised deceiver of women, experienced in presenting a false appearance of respectability and military distinction, and already versed in the forgery of financial instruments, that he would, within a matter of months, turn against the woman whose trust he had gained and whose life he would end. The case of Camille Holland's death and the trial that followed it drew coverage across the national press in the summer of 1903, coverage sustained in large part by the unusual duration of the mystery that had preceded the discovery of her remains. Newspapers of the period reported the proceedings at Chelmsford under headlines invoking the Moat Farm mystery, a framing that reflected the nearly 4 years during which Camille Holland's fate had remained unknown even as Dougal continued to draw upon her funds. In the years following the trial, a full transcript of the proceedings was published as part of the notable British Trials series, issued under the title Trial of Samuel Herbert Dougal, a form of publication reserved for cases judged to hold lasting interest for students of criminal law and for the broader reading public. A separate account, published closer to the events themselves under the title The Secret of the Moat Farm, offered a contemporary, popular narrative of the case, drawing upon the details that had emerged during the investigation and trial. Interest in the case has persisted regionally within Essex in the more than a century since the trial concluded. The Saffron Walden Historical Society, based in the market town nearest to Clavering, has continued to research and publish material relating to the case, drawing upon local records and documents connected to the farm and to the families involved. The Essex Police Museum has likewise maintained the case within its records of notable investigations conducted by the County Constabulary, preserving it as part of the institutional history of policing within Essex. A modern book-length account of the case, published under the title The Moat Farm Murder, has extended this record of continued attention into recent decades, situating the case within the broader literature of British criminal history. The case of Camille Holland has come, within this body of continued attention, to occupy a particular place among the criminal narratives of the late Victorian and early Edwardian periods, understood chiefly through the figure of the confidence trickster who preyed upon a woman of independent means. Camille Holland's circumstances, an unmarried woman in her 50s, possessed of inherited wealth, and answerable to no husband or immediate family in daily oversight of her affairs, reflected a category of women that had grown more numerous across the second half of the 19th century, as inheritance patterns and the slow expansion of women's legal control over property allowed a greater number of women to hold and manage capital independently. Such independence offered these women a measure of freedom uncommon among earlier generations, yet it also left them, in the absence of the oversight that marriage or close family supervision might otherwise have provided, more exposed to men such as Dougal, who made a practice of identifying and courting women in precisely this position. The sustained deception that followed Camille Holland's death, in which Dougal maintained his occupation of Moat Farm, and his fraudulent drawing upon her funds for very nearly 4 years, depended upon the limited mechanisms available in the England of the period for verifying a person's continued existence or the authenticity of a signature presented at a bank or to a tradesman. A rural district, such as that surrounding Clavering, in which a gentleman of apparent means might settle upon a farm and be accepted at his own account by neighbours and tradesmen without extensive independent inquiry, offered exactly the kind of setting in which such a deception could be sustained across so long a period. It was, in the end, not any direct discovery of Camille Holland's absence that first drew official attention to Moat Farm, but the more prosaic matter of a forged signature presented in the course of ordinary financial business, a detail that reflects the manner in which many extended frauds of the period came to light through the eventual scrutiny of the paper trail rather than through any earlier suspicion of the underlying crime. The farmhouse at the centre of this record, purchased under the name Coldham's Farm in the early months of 1899, has since been known, in every account written of the case, by the name it acquired through the events themselves, Moat Farm. The water-filled ditches that had once served the practical purposes of an older agricultural age, becoming instead the defining and permanent association of the property with the killing that took place there, and with the 4 years of concealment that followed it. The bridge crossing those waters, and the ground beneath the planted shrubs where Camille Holland's remains lay undiscovered for so long, remain within the record of this case the fixed and physical anchor of an account that otherwise turned upon documents, signatures, and the slow accumulation of suspicion that finally, in the spring of 1903, brought investigators to dig. Following the conclusion of the inquest and the committal proceedings, arrangements were made for the burial of Camille Holland's remains, which had by that time been formally released following their examination and the conclusion of the coroner's proceedings. The record available for this account does not establish the precise location of her interment with certainty, and this account does not attempt to supply that detail beyond noting that her burial followed the ordinary course observed once a coroner's proceedings and the medical examination connected to them had concluded. Her estate, substantial by the standards of the period and drawn from the inheritance that had passed to her through her aunt, became, following her death, a matter for probate and for distribution among her surviving relatives. The very financial independence that had made her a target for Dougal, now passing, in the aftermath of the case, into the hands of family members who had waited nearly 4 years without word of her. The scale of the search conducted at Moat Farm in April of 1903 was, by the account preserved in local record, considerable, drawing the attention of residents throughout the district surrounding Clavering as word spread of the digging underway at the farm. Officers worked across a period of weeks, examining ditch after ditch upon the property, in conditions made difficult by the wet character of the Essex clay and by the sheer extent of ground, requiring examination before the disturbed earth beneath the planted shrubs was finally identified and opened. The search became, in the weeks before the discovery of the 27th of April, a matter of considerable local interest and speculation. Farmers and labourers in neighbouring holdings, aware that the constabulary had turned its attention to the isolated property behind its screening hedges, though the purpose and eventual outcome of the digging were known with certainty only once the remains themselves were recovered. The trial at Chelmsford in June of 1903 drew, in its turn, considerable numbers of spectators and members of the press to the Shire Hall. The proceedings, conducted within a courtroom that had, across the decades of its use for the Essex Assizes, heard a great many cases but few that had attracted the sustained public attention given to the Moat Farm matter. Contemporary press accounts of the trial describe Dougal's demeanour in the dock as composed through much of the proceedings, a composure that press correspondents of the period noted with the kind of observational detail characteristic of assize reporting, though the surviving accounts do not extend to any fuller psychological characterization of the defendant beyond such observations of his outward bearing during the hearing of the evidence against him. Following the pronouncement of sentence on the 23rd of June, The interval of 3 weeks before the execution was carried out at Chelmsford Prison on the 14th of July, followed the ordinary interval customary between sentencing and execution in capital cases of the period, allowing time for any appeal or petition to be considered, though, as already noted, none is recorded as having been lodged in Dougal's case. On the morning of the execution itself, a small crowd gathered outside the walls of Chelmsford Prison, in keeping with the practice observed at English executions of the period, at which the public was excluded from the execution itself, conducted within the prison walls since the change in the law in 1868, but at which a notice of the execution, having been carried out, was customarily posted at the prison gate once the sentence had been completed, for the information of those gathered outside. In the aftermath of the trial and execution, Moat Farm itself passed from Dougal's occupation, the property having been forfeited in the ordinary course of the legal proceedings connected with his conviction and with the settling of Camille Holland's estate. The farm was subsequently sold, passing into new ownership in the years that followed the case, and it continued to be known in every subsequent reference and record by the name Moat Farm, the earlier designation of Coldham's Farm having by that point fallen entirely out of use. The moat and the bridge that had given the property its enduring name remained, in the decades that followed, physical features of the landscape around Clavering, associated in local memory with the events of 1899 and 1903, long after the farm itself had passed through successive owners, unconnected with the case. The years in which Camille Holland managed her own inheritance and conducted her own financial affairs in Bayswater fell within a period of gradual change in the legal position of women with respect to property in England. The Married Women's Property Acts, passed in 1870 and again in an expanded form in 1882, had begun to establish in law a woman's right to hold and control property in her own name, independent of a husband, a right that, for an unmarried woman such as Camille Holland, was in one sense already assumed, since English law had long permitted an unmarried woman, a feme sole, to hold property and enter into contracts in her own right. What these later statutes changed was chiefly the position of married women, extending to them a form of the independence that unmarried women of means, such as Camille Holland, had already possessed. Her situation, an unmarried woman controlling a substantial private fortune without the oversight of a husband or a resident guardian, was accordingly not a novelty created by recent legislation, but reflected a longer-standing legal category, one that had, by the close of the 19th century, come to include a growing number of women as inheritance patterns and the slow accumulation of family capital across generations placed increasing sums directly into the hands of unmarried daughters, sisters, and nieces. This legal independence carried with it, as the case of Camille Holland would come to demonstrate, no corresponding social or institutional protection against the deliberate deception of a woman by a man who represented himself falsely. No banking or legal mechanism of the period required that a woman such as Camille Holland demonstrate to any external authority the soundness of her judgment in choosing a companion, nor did any institution exist to verify on her behalf the claims a suitor made about his own history, his military record, or his prior marriages. The protection that a family, resident nearby and attentive to a woman's affairs, might have offered was, in Camille Holland's case, attenuated by the death of the aunt with whom she had lived for so many years, and by the relocation of her own life to London, at a remove from whatever relatives remained connected to the family's earlier circumstances in Liverpool. It was within this space, a woman of means, unmarried, once again without the aunt, who had for so long provided her household and her company, that Samuel Dougal identified an opportunity, at the Earl's Court exhibition in the autumn of 1898, that he would pursue across the following months to its fatal conclusion at Moat Farm. The rural setting of the crime itself, a farm selected specifically for its isolation from close neighbours and its distance from the oversight that a more populous district might have provided, reflected a further dimension of the vulnerability that attended Camille Holland's circumstances. Clavering and the surrounding parishes of northwest Essex, sparsely settled and given over to agricultural life, governed by the rhythms of planting and harvest rather than by any close civic administration, offered exactly the kind of setting in which a newcomer's account of himself, and subsequently his account of a companion's sudden absence, could pass without early challenge. It was this combination, a woman of independent means separated from close family oversight, and a rural property selected for its remove from casual observation, that together permitted the deception, first begun in the autumn of 1898, to be sustained, through forgery and false explanation, for very nearly 4 years before the ordinary scrutiny applied to a forged financial instrument finally brought the matter to official attention in the spring of 1903. The investigation concluded with a verdict returned and a sentence carried out. The case was entered into the historical record. It has remained there. The verdict stood. The case became part of British memory. That is where the record of the first case ends. We turn now to a second story, quieter than the first and far less remembered, one that unfolded in an earlier decade and in a different corner of England altogether, in a small chapel town where everyone knew everyone else by name, and yet the case turned upon the same question that no inquest could finally answer. The case of Harriet Monckton begins in Bromley, Kent, in the autumn of 1843. Bromley at that time was a market town on the road leading south out of London, a settlement of modest size that had not yet been drawn into the growing suburban expansion of the capital. The town retained the character of a Kentish market centre, with a high street lined by shops, inns and private residences, and a surrounding countryside still given over largely to agriculture. The population of Bromley in this period numbered only a few thousand persons, a figure that made it a place in which residents were acquainted with one another across trades, congregations and households, and in which a sudden death within a respected institution could not pass without notice from nearly every quarter of the town. Among the institutions that anchored the social and religious life of Bromley was the Congregational or Independent Chapel, a nonconformist place of worship that stood apart from the established Church of England and drew its congregation from among tradespeople, teachers and other residents of the town who had chosen a stricter and more austere form of Protestant observance. Nonconformist chapels of this kind were a significant feature of English religious life in the early Victorian period, particularly in market towns of the southeast, and their congregations tended to be close-knit, bound together by regular attendance, shared religious instruction, and a web of personal relationships that extended well beyond the hours of formal worship. The minister of such a chapel held a position of considerable influence within the community, responsible not only for the conduct of services, but for the moral and spiritual oversight of the congregation as a whole. It was within this setting, at the Bromley Congregational Chapel, that Harriet Monckton was known as an active and committed member. She was, by the description that survives in the record, a young woman of respectable parentage, and her conduct within the chapel community was regarded as consistent with the religious habits expected of a devout nonconformist. She was employed as a teacher, a position that placed her in regular contact with other members of the congregation, including a fellow teacher with whom she maintained a close association. The precise details of Harriet Monckton's birth, including the exact date and place and the names and occupations of her parents, are not established with certainty in the surviving record. The account that follows proceeds from what the coroner's inquest and subsequent research have documented, and where the record is silent, it is treated as silent rather than filled with invention. Harriet Monckton was 23 years of age in November of 1843. She had built her life around the routines of the chapel and the schoolroom, routines that in most respects mirrored those of any respectable young woman of her situation in a provincial English town of the period. She attended services regularly. She taught. she maintained friendships within the small circle of the congregation. Nothing in the records suggests that her outward conduct departed from what her community expected of her, and it was this outward respectability that made the events of early November 1843 so difficult for the town of Bromley to absorb. The chapel itself stood as the physical centre of this world, a building of worship that also housed the ordinary domestic conveniences required to support a congregation gathering regularly for services and instruction. Among these was a privy, an outdoor structure set behind the main chapel building, of the kind common to nearly every institution and private residence in England before the widespread introduction of indoor sanitation later in the Victorian period. It was an unremarkable feature of the property, used by members of the congregation and by those who lived or worked in proximity to the chapel, and it would become, within a matter of days, the scene of a death that the town of Bromley would spend the better part of 3 years attempting, without success, to resolve. The sensory character of Bromley in November of 1843 would have been that of any small English town entering the darker months of the year, with short daylight hours, coal smoke rising from household chimneys, and the traffic of the London road passing through the town centre. The chapel stood among the other buildings of the town, a place set apart by its religious purpose, but not isolated from the daily rhythms of commerce and domestic life that surrounded it. It was in this ordinary setting, among people who worshipped together, taught together, and moved within the same narrow social circle, that Harriet Monckton's life came to its end. Harriet Monckton moved in the months leading up to November 1843 within a social world defined almost entirely by the chapel and its congregation. Her closest associations were with fellow members of that community, including teaching colleagues and others who attended services regularly alongside her. Among those named in connection with her in the surviving record are several men and at least one woman with whom she maintained some degree of personal closeness, though the precise nature of these relationships is not established with the certainty that would allow a confident account of her private life in the weeks before her death. What the medical examination conducted after her death did establish was that Harriet Monckton was, at the time of her death, approximately 6 months pregnant. This finding was not known publicly before her death, and its discovery at the post-mortem examination introduced a circumstance that shaped the direction of suspicion within the town for years afterward. An unmarried woman in a nonconformist chapel community expecting a child outside of marriage occupied a position of considerable social vulnerability in 1843. The concealment of a pregnancy in such circumstances was not unusual for the period, given the severity of the social consequences that typically followed its discovery, and the record does not establish how widely, if at all, Harriet Monckton's condition was known among her associates before her death. The identity of the father of the child Harriet Monckton was carrying was never established by the inquest, and it has not been established since. Several men within her circle of acquaintance were named as persons of interest in the subsequent investigation, but the record does not permit any of them to be identified with confidence as responsible for her pregnancy, nor does it permit a confident account of what she intended to do or whom she intended to tell in the weeks that remained to her. The pregnancy itself, however, stands as one of the few certain facts established by the medical examination, and it is treated in this account only as that, a documented finding, not an invitation to speculation about matters the record does not resolve. On the evening of Monday, the 6th of November, 1843, Harriet Monckton was, according to the surviving record, in the vicinity of the chapel. The precise sequence of her movements that evening, including who she was last seen with and at what hour, is not established with the detail that would allow a confident narrative of her final hours. The surviving depositions and later research do not provide the level of specificity that would permit an account of her last movements. beyond the bare fact that she was in Bromley, near the chapel, on the evening in question, and that by the following morning she was dead. Where the record falls silent on these particulars, this account does not attempt to supply them. What is established is that Harriet Monckton died that night from the effects of poison. The substance identified was prussic acid, also known as hydrogen cyanide, a fast-acting poison that produces death within a short period following ingestion. The examining surgeon's findings, discussed further in connection with the medical examination, established this cause of death with a degree of confidence that was not seriously contested during the long course of the subsequent inquest. What was contested, and what remained unresolved for nearly 3 years afterward, was the question of how the poison came to be administered, and by whose hand. The circumstances leading up to Harriet Monckton's death, then, present a case in which the central facts, her presence at the chapel, her pregnancy, and her death by poisoning that same night, stand established, while the connecting details, her state of mind, her recent conversations, her plans and her final movements, remain outside the reach of the surviving record. This account proceeds on that basis. It reports what the inquest and subsequent research have documented, and where those sources are silent, this account does not attempt to speak in their place. Before the crime itself can be examined, some account is required of the men whose names became attached to the case as persons of interest, though it must be stated clearly at the outset that none of them was ever formally charged with any offence in connection with Harriet Monckton's death. The record establishes their identities, their occupations, and in some cases their later lives, but it does not establish that any of them administered the poison that killed her, and this account does not treat suspicion as equivalent to guilt. Among the men named in connection with the case was Thomas Blackstone Churcher, born in Bromley in 1818, who was by occupation a shoemaker, and in addition worked as a debt collector within the town. Churcher was a member of the Congregational Chapel congregation, and was known to Harriet Monckton through that shared association. He became, over the course of the investigation and the long inquest that followed, one of the most persistently named suspects in the case, though he was never arrested and never charged with any offence. The record of Thomas Churcher's later life is documented with a degree of detail unusual for a man who spent years under public suspicion without ever facing formal accusation. In 1844, the year following Harriet Monckton's death, Churcher married a woman named Mary Ann Milstead. The couple went on to have 6 children together. Churcher later relocated from Bromley to Sydenham, then a separate district southeast of London, where he continued to reside for the remainder of his life. He died in 1876, having lived for more than 3 decades after the death of Harriet Monckton under a cloud of local suspicion that was never resolved into either formal accusation or public exoneration. Also named in connection with the case was the Reverend George Verrill, who served as minister of the Bromley Congregational Chapel at the time of Harriet Monckton's death. As the chapel's minister, Verrill occupied a position of considerable authority and influence within the congregation, responsible for the spiritual guidance of its members, including Harriet Monckton herself. He too was named as a person of interest during the course of the investigation and the inquest, and he too was never charged with any offence. Verrill continued in his vocation as a minister following the events of 1843, and the surviving record establishes that he died in 1880. Whether he continued to serve the same Bromley congregation throughout the years following Harriet Monckton's death, or moved to another ministry, is not established in the sources available for this account, and this account does not assert a continuity that the record does not support. 2 further names appear in connection with the case, though the documentation supporting their roles is considerably thinner than that available for Churcher and Verrill. Richard Field is named in secondary accounts as a man who had, at some point prior to her death, maintained a romantic association with Harriet Monckton. His occupation and the precise nature of his connection to her are not established with confidence in the sources available for this account. Frances Williams is named as a fellow schoolmistress and a close companion of Harriet Monckton, a woman within the same teaching and chapel circle. Beyond these bare identifications, the record does not permit a confident account of either Field's or Williams' role in the events surrounding Harriet Monckton's death. It should be stated plainly that the fuller characterisation of these four individuals, Churcher, Verrill, Field, and Williams, as figures bound to Harriet Monckton by particular emotional attachments, whether romantic devotion, spiritual authority exercised improperly, or personal rivalry, derives substantially from later literary treatment of the case rather than from the surviving depositions themselves. The coroner's inquest established that these individuals were known to Harriet Monckton and that they were examined in connection with her death. It did not establish the psychological or romantic dimensions of those relationships with the certainty that would permit this account to present them as settled fact. Where this account refers to these four figures, it does so by their documented roles: chapel minister, shoemaker, and debt collector, named former associate and fellow schoolmistress, and does not attribute to them motives or emotional states beyond what the record supports. The crime itself, as it is established by the surviving record, occurred on the night of Monday, the 6th of November, 1843, in the privy situated behind the Bromley Congregational Chapel. The location, standing on chapel grounds and used regularly by members of the congregation, gave the death a particular character in the eyes of the town, occurring as it did within the physical bounds of the institution most associated with respectability and religious observance in Bromley. The method of death, poisoning by prussic acid, was one that acted with considerable speed, and the surviving record does not indicate that Harriet Monckton's body, when discovered, showed signs consistent with a prolonged struggle. Harriet Monckton's body was discovered in the privy on the morning of Tuesday, the 7th of November, 1843. The identity of the person who found her and the precise hour at which the discovery was made are not established in the sources available for this account. What is established is that the discovery occurred within chapel grounds, that the deceased was quickly identified as a respected and religiously active young member of the congregation, and that news of her death spread through the town with the speed characteristic of a small community in which such an event touched, directly or indirectly, a very large proportion of the residents. The initial response within Bromley was one of considerable and lasting shock, a reaction attributable both to the manner of Harriet Monckton's death and to the setting in which it occurred, a place of worship rather than a location associated with danger or violence in the ordinary expectation of the town's residents. The investigation that followed the discovery of Harriet Monckton's body proceeded along lines somewhat different from those that would become familiar in later decades of the Victorian period, when a formal detective branch and an established model of provincial criminal investigation had developed more fully. In 1843, the primary mechanism for examining an unexplained death of this kind was the coroner's inquest, a legal proceeding convened to determine the cause of death and, where possible, to identify responsibility for it. Local constables were involved in the initial response to the discovery of the body, and the surviving record, including a file held among the papers of the Metropolitan Police, indicates that officers connected with the Metropolitan Force had some involvement in the case, a reflection of the seriousness with which the death was regarded even at a distance from the capital. The investigation proceeded through the examination of witnesses drawn from Harriet Monckton's own circle of acquaintance, a circle that included the men and the one woman named earlier in this account. Statements were taken from those who had known her, worshipped alongside her, or worked with her in the schoolroom. The investigation sought to establish her movements in the days and hours before her death, her state of health, and any circumstances that might account for the presence of poison in her body. Despite these efforts, conducted over an extended period, No arrest was made at any point in connection with Harriet Monckton's death, and no individual was ever formally charged with administering the poison that killed her. The witnesses examined during the course of this inquiry were drawn primarily from those who attended the Bromley Congregational Chapel and who could speak to Harriet Monckton's habits, her associations, and her conduct in the period leading up to her death. Fellow teachers, chapel members, and household acquaintances were called upon to describe what they had observed of her in the days before the 6th of November, though the surviving record indicates that their accounts did not converge upon a single, uncontested version of her final movements. Some statements addressed her general disposition and her attendance at chapel functions in the preceding weeks. Others touched upon her associations with the men later named as persons of interest, without establishing with precision the nature or extent of those associations. The investigating authorities were required to weigh testimony that was, in several particulars, incomplete or difficult to reconcile from one witness to the next, a difficulty that would persist throughout the long course of the proceedings that followed. Constables attached to the local force examined the privy itself and the grounds surrounding the chapel in the days following the discovery of the body, seeking physical evidence that might indicate how the poison had come into Harriet Monckton's possession or been administered to her. The surviving record does not describe the recovery of any implement or container definitively linked to a particular individual, a gap that contributed to the protracted and inconclusive character of the investigation as a whole. Inquiries were made among local chemists and druggists regarding the recent sale of prussic acid, a substance that, in 1843, retained legitimate uses in trades such as tanning, photography, and the destruction of vermin, and was therefore not itself unusual to find in circulation within a market town of Bromley's size. Establishing whether any particular purchase of the substance could be traced to a specific person connected with Harriet Monckton proved, according to the surviving record, a task the investigation was unable to resolve conclusively. The investigation also extended to an examination of Harriet Monckton's correspondence and personal effects in an effort to determine whether any letters or written material might indicate the identity of the father of her unborn child, or otherwise illuminate the circumstances of her final weeks. What, if anything, was recovered in this manner is not detailed with certainty in the sources available for this account. The investigating authorities were, in this respect as in others, working within the limitations of an inquiry conducted without the forensic resources that would become available to criminal investigation in later decades. Relying instead upon witness testimony, the observations of the examining surgeon, and the deliberations of a coroner's jury convened to weigh the evidence as it stood. The medical examination of Harriet Monckton's body was conducted in the days immediately following its discovery, undertaken by a surgeon whose name is not established with certainty in the sources available for this account. The examination determined that death had resulted from the ingestion of prussic acid, a poison capable of producing death within minutes of its administration, and one that leaves comparatively little external evidence of violence upon the body. The surgeon's findings on this point were not seriously contested during the subsequent proceedings, and the cause of death, once established, was not the subject of ongoing dispute in the way that the question of responsibility for its administration remained. The same examination revealed that Harriet Monckton was, at the time of her death, approximately 6 months pregnant, a finding that had not been known publicly before the post-mortem examination was conducted. This discovery altered the course of the investigation from that point forward, directing attention toward those men within her circle of acquaintance who might have fathered the child, and introducing a motive that the investigating authorities, and later the coroner's jury, were required to weigh against the available testimony. The surgeon's report did not identify the father of the child, and no subsequent examination or testimony succeeded in establishing his identity with certainty. The medical findings taken together established the manner and immediate cause of Harriet Monckton's death with reasonable confidence, while leaving open the questions of intent, opportunity, and responsibility that the investigation, as a whole, was unable to resolve. The coroner's inquest into the death of Harriet Monckton was opened within days of the discovery of her body, in accordance with the standard legal procedure of the period for examining a death occurring under unexplained circumstances. Inquests of this kind were customarily convened in a convenient public location rather than in a dedicated courtroom, and at least one session of the proceedings in this case was held at the Swan and Mitre, a public house in the centre of Bromley, a practice common throughout England in the first half of the 19th century, when purpose-built facilities for such hearings were not universally available, even in towns of reasonable size. The jury empanelled to hear the evidence in Harriet Monckton's case was drawn, as was customary, from among local residents, tasked with weighing the testimony presented to them, and returning a verdict as to the cause of death, and where the evidence permitted the identity of any person responsible for it. What distinguished the inquest into Harriet Monckton's death from the great majority of such proceedings conducted in England during this period was its extraordinary duration. Rather than concluding within days or, at most, a few weeks, as was typical, the inquest was repeatedly opened, adjourned, and reopened over a span of time that extended to very nearly 3 years. The precise number of individual sessions convened during this period, and the exact dates on which each was held, are not established with certainty in the sources available for this account, though the pattern that emerges from what has survived is one of a jury and a coroner returning again and again to evidence that could not be made to yield a definite conclusion, adjourning in the hope that further testimony or further time might resolve the question of responsibility, and finding, session after session, that it did not. The witnesses recalled before the inquest over these repeated sessions included Thomas Churcher, the Reverend George Verrill, and others among Harriet Monckton's circle of chapel and teaching associates, each required to account for their movements and their relationship to the deceased on more than one occasion, as the proceedings extended across months and then years. The repeated recall of the same witnesses, examined and re-examined as the inquest dragged on, reflected the difficulties the coroner and jury faced in reconciling testimony that touched upon sensitive and closely guarded matters, including the paternity of Harriet Monckton's unborn child, with the ordinary standards of proof required to name a specific individual as responsible for her death. Some secondary accounts of the case suggest that the coroner himself, over the long course of the proceedings, formed a private view as to where responsibility most likely lay. Such an impression, however, was never translated into a formal charge against any individual, and this account does not treat a private suspicion, however persistently held, as equivalent to an established finding of the inquest. When the inquest finally concluded, very nearly 3 years after it had first been opened, the jury returned a verdict of wilful murder committed by some person or persons unknown. This verdict confirmed, as a matter of legal record, that Harriet Monckton had been unlawfully killed, while stopping short of naming any individual as responsible for that killing. It was, in the framework of English law, as it stood in 1843, a verdict that closed the formal inquiry into the cause of her death without closing the broader question of who among those examined, if any, had administered the poison that killed her. No arrest followed the verdict. No individual was subsequently charged, tried, or brought before the assizes in connection with Harriet Monckton's death. The case, having exhausted the mechanism available to it under the law of the period, passed from active investigation into the status of an unresolved matter, its questions preserved in the depositions and testimony gathered over 3 years of intermittent proceedings, but never answered by any court. The absence of any conviction in the case of Harriet Monckton left the town of Bromley to manage in its own fashion a death that the formal machinery of coroner and jury had been unable to resolve. In a community of the size Bromley possessed in the 1840s, where chapel, schoolroom, and market square drew the same limited population into daily contact with one another, the unresolved verdict did not permit the matter to be set aside. Those named during the long course of the inquest, examined and re-examined across nearly 3 years of adjourned sessions, continue to live and work within the same streets, attend the same shops, and in some instances worship within the same chapel walls, as neighbours who had heard every syllable of testimony given against them without ever hearing a verdict that either confirmed or dispelled the suspicion attached to their names. Secondary accounts of the period describe this atmosphere as one of persistent rumour, in which the absence of a formal finding did nothing to quiet informal judgment, and in which reputations already known to the town before November of 1843 were permanently shadowed by association with an unsolved death on chapel ground. This condition bore most heavily, according to what the record preserves, upon those men whose names had been most frequently recalled before the coroner. Thomas Church's continued residence in Bromley in the immediate years following the verdict placed him within a town that had watched him give testimony on repeated occasions, in a public house given over to the purposes of an inquest that could not conclude, and that had, by the time the jury finally rose for the last time, formed its own private opinions regardless of what the law itself had been able to establish. It was against this backdrop that Church's marriage to Mary Ann Milstead in 1844 took place, a union entered into within a single year of the verdict in a town where his name had featured prominently throughout the proceedings that preceded it. The record does not indicate whether this marriage drew particular comment in Bromley at the time, nor whether Church's standing within the chapel congregation, of which Harriet Monckton had herself been so devoted a member, survived the years of testimony intact. What is documented is the practical shape his life subsequently assumed, a household established, 6 children born into it over the following years, and a trade in shoemaking and debt collection carried on in the town where the unresolved death had occurred. Church's eventual departure from Bromley for Sydenham, some years after the inquest had closed, removed him from the immediate vicinity of the chapel and the privy behind it, and placed him within a different, though not distant community on the southeastern approaches to London. Sydenham in the middle decades of the 19th century was itself undergoing considerable change, its character shifting with the growth of suburban building and improved transport links to the capital, and it was within this newer and less settled community that Church spent the remaining years of his life. He died there in 1876, 33 years after the death of Harriet Monckton, having outlived the woman whose death had shadowed so much of his adult life by more than 3 decades. Research conducted in more recent years by a local historical society concerned with the preservation of cemetery records in the Brockley and Ladywell area has traced the location of his grave and confirmed the outline of this later biography, establishing that whatever suspicion attached to his name in 1843 was never resolved into either conviction or public exoneration during the whole of his subsequent lifetime. The Reverend George Verrill's position within the case carried a different weight, owing to his office as minister of the very chapel within whose grounds Harriet Monckton's body had been found. A minister in a nonconformist congregation of this period held a role that combined spiritual authority with a degree of pastoral oversight extending into the private conduct and moral welfare of every member of his flock. And it was this proximity of office to the circumstances of Harriet Monckton's death, a young woman under his spiritual charge, found dead and secretly pregnant on the ground of the chapel he served, that placed his name so persistently before the coroner's jury across the long course of the inquest. The surviving record establishes that Verrall was examined as a witness on more than one occasion during the proceedings, and that he, like Churcher, was never charged with any offence. He continued in his vocation following the conclusion of the inquest, and the record establishes his death in 1880, 37 years after Harriet Monckton's death, without establishing whether he remained at the Bromley congregation throughout that period or removed to another charge elsewhere. The chapel itself continued to serve its congregation in the years that followed, its ordinary functions of worship and instruction resuming even as the privy behind it retained. For those residents are old enough to remember November of 1843, an association it could not entirely shed. The social conditions that shaped Harriet Monckton's circumstances in the months before her death reflect a broader pattern well documented in the religious and domestic life of provincial England during the early Victorian period. Nonconformist congregations of the kind gathered at the Bromley Congregational Chapel placed considerable emphasis upon the visible moral conduct of their members, an emphasis that extended with particular severity to the conduct of unmarried women. A pregnancy occurring outside of marriage, within such a community, carried consequences that went beyond private shame, threatening a woman's standing within her congregation, her continued employment where that employment depended upon a reputation for moral respectability, as it did for a school teacher, and her position within the network of family and social relationships that constituted her entire social world. It was a circumstance that gave a woman in Harriet Monckton's position powerful reasons to conceal her condition for as long as concealment remained possible, and equally powerful reasons for any man responsible for that condition, married or unmarried, ordained or otherwise, to wish the matter to remain hidden. The surviving record does not establish that this dynamic caused Harriet Monckton's death, but it establishes the social terrain within which her death occurred, a terrain in which the discovery of her pregnancy at the post-mortem examination carried implications the coroner's jury could not set aside. Bromley's chapel-going population in 1843 numbered only a fraction of the town's total residents, the greater part of the parish continuing to worship within the established Church of England, and it was within this small and nonconformist circle that Harriet Monckton's entire social world had been constructed. The insularity of such a circle, in which teacher, minister, and congregant were bound together by regular and repeated contact across services, chapel meetings, and the shared instruction of children, meant that whatever crisis attended Harriet Monckton's final months could not have unfolded outside the awareness, however partial, of those closest to her. It is this insularity that the inquest's repeated adjournments seem in retrospect to reflect, a jury and a coroner drawn from a community small enough that every witness called before them was already known to every other witness, and in which the ordinary distance a court might otherwise maintain between the bench and those testifying before it scarcely existed at all. The National Archives holds among its records a file connected with the case, catalogued within the papers of the Metropolitan Police, and referencing the investigation into the death of Harriet Monckton at Bromley, with Thomas Churcher recorded among those suspected in connection with it. The survival of this file, more than a century and a half after the events it documents, has allowed later researchers to confirm the essential outline of the case, including the date of Harriet Monckton's death, the location of its discovery, and the identity of at least one of the men examined in connection with it, even where the finer details of witness testimony and the coroner's private deliberations have not survived in equally complete form. It is this archival record, together with the cemetery research conducted into Thomas Churcher's later life, that has permitted the case to be reconstructed with the degree of confidence this account has attempted to observe, distinguishing throughout between what the surviving documentation establishes and what remains, more than a century and a half later, beyond recovery. The case of Harriet Monckton did not achieve the wide national notoriety attached to some unsolved deaths of the Victorian period, and for much of the 20th century it remained known chiefly to those with a particular interest in the local history of Bromley and the surrounding district of Kent. Its persistence in the historical record owed a great deal to the survival of the coroner's depositions and the Metropolitan Police file, documents that preserved the names, testimony, and procedural history of the case in sufficient detail to permit later reconstruction, even as the wider public memory of the case faded. It was not until the early 21st century that Harriet Monckton's story reached a substantially wider audience through a work of historical fiction published in 2018 by the author Elizabeth Haynes, grounded explicitly in the surviving coroner's reports and witness depositions held among the National Archival record. The novel presented an imagined account of the relationships among Harriet Monckton, Thomas Churcher, the Reverend George Verrill, and the other figures named in the case, drawing upon the documented facts of the inquest, while supplying, in the manner of historical fiction, a psychological interpretation of their private motives and attachments that the surviving depositions themselves do not establish. The novel received attention within the community of readers and reviewers particularly concerned with crime fiction grounded in historical record, and it is largely through this later literary treatment that the case of Harriet Monckton has become known beyond the immediate district of Bromley. Separate from this literary treatment, local historical research into the district's cemetery records has continued to add to the documented record of the case, particularly in tracing the later life of Thomas Churcher following his departure from Bromley. This research, conducted by a society concerned with the preservation of burial records in the Brockley and Ladywell area of southeast London, has established the location of Churcher's grave and confirmed the details of his marriage, his family, and the date of his death, adding a documented coda to a case that otherwise concluded, so far as the formal legal record is concerned, with the inconclusive verdict returned by the coroner's jury in 1846. No ballad, stage production, or screen adaptation of the case has been identified among the sources available for this account, distinguishing it from certain other unsolved deaths of the period that passed more directly into popular culture through such means. The historical significance of the case of Harriet Monckton rests less upon its scale, a single victim, no trial, no execution, than upon the unusual completeness with which its central uncertainty has been preserved. The surviving depositions and the extended, repeatedly adjourned inquest that produced them offer a detailed record of a Victorian coroner's court, struggling across nearly 3 years to resolve a death within a small and closely bound religious community, a struggle that ultimately failed to produce a name to set against the verdict of willful murder. The later documentation of Thomas Churcher's ordinary domestic life, his marriage, his children, his trade, his eventual death in Sydenham more than 3 decades later, stands in the record as an unusual instance of a named suspect in an unresolved killing whose subsequent biography can be traced in full. A man who lived out an entire adult life under a suspicion that neither convicted nor cleared him. The Swan and Mitre, where at least one session of the inquest into Harriet Monckton's death was convened, stood among the principal public houses of Bromley's town centre, a building accustomed to the ordinary business of an inn, the accommodation of travellers passing along the London road, and the provision of a meeting room for local business of various kinds. The practice of holding a coroner's inquest within such an establishment, rather than within a dedicated courtroom, was widespread throughout England in this period, reflecting both the absence of purpose-built facilities in many towns and a long-standing tradition by which the coroner, an official whose office predated much of the modern apparatus of criminal justice, convened his jury wherever a room of sufficient size could be found close to the place where the body lay. Jurors summoned to serve upon such an inquest were drawn from among the resident householders of the district, men who might, on any other evening, have occupied the same public rooms of the Swan and Mitre for purposes entirely unconnected with the law, and who found themselves instead seated in judgment upon a case involving a young woman many of them had known personally, a minister several of them had heard preach, and a shoemaker whose trade several of them had likely patronised. The mechanics of such a proceeding required the coroner first to view the body, a legal obligation that placed him and his jury in direct physical proximity to the remains of Harriet Monckton before any testimony was heard, a practice intended to ground the jury's subsequent deliberations in the physical fact of the death before them. Witnesses were then called in turn, examined under oath, their testimony recorded by a clerk in the form of a deposition, a written record that could be read back, referred to in later sessions, and, where a witness's account shifted or contradicted itself across the intervening months of adjournment, compared against what that same witness had said before. It was this repeated examination, session after session, across nearly 3 years, that gave the case its unusual documentary depth, each adjournment adding a further layer of testimony to a written record that grew, over time, into an extensive account of the private lives, associations, and movements of everyone connected with Harriet Monckton, even as it failed to resolve the single question upon which the jury's eventual verdict depended. Prussic acid, the substance identified as the cause of Harriet Monckton's death, occupied a peculiar place among the poisons available in England during the 1840s, a period before the passage of legislation that would later restrict the sale of such substances to registered pharmaceutical chemists under conditions requiring the purchaser's name and purpose to be recorded. In 1843, hydrogen cyanide in its various commercial preparations found legitimate use across a range of trades, including the tanning of leather, a process not unconnected to Thomas Church's own occupation as a shoemaker, as well as in the preparation of certain dyes, in photography, then still a developing art, and in the destruction of vermin and garden pests, a use common enough that its presence in a household or workshop in a market town such as Bromley would not, by itself, have excited particular comment. This wide, legitimate availability was precisely what made the investigation's efforts to trace the source of the poison used against Harriet Monckton so difficult to bring to a satisfactory conclusion. Inquiries made among the chemists and druggists trading in Bromley and its surrounding villages sought to establish whether any recent purchase of the substance could be connected to a specific individual among those already named in the case, but the surviving record does not indicate that any such purchase was ever conclusively traced, leaving the means by which the poison came into Harriet Monckton's presence as unresolved, in the end, as the question of who administered it. The schoolroom in which Harriet Monckton taught, and in which Frances Williams is recorded as having served alongside her, would have followed the ordinary pattern of instruction provided to the children of a nonconformist congregation in this period, combining basic literacy and numeracy with religious instruction grounded in the doctrines and scriptural emphasis of the independent chapel tradition. Positions of this kind were customarily held by unmarried women, whose continued employment depended upon the maintenance of an unblemished reputation within the community that employed them, a condition that placed particular weight upon the concealment Harriet Monckton appears to have practiced in the months before her death. Frances Williams's own position within this arrangement, described in secondary treatment of the case as one of particular closeness to Harriet Monckton, is documented in the surviving record only to the extent of confirming her presence within the same teaching and chapel circle. The surviving depositions do not establish the fuller emotional character of that friendship with the certainty required to state it as settled fact, and this account does not go beyond what has been documented. Richard Field's connection to the case rests upon a similarly narrow documentary foundation, his name preserved in the record as a man who had, before Harriet Monckton's death, maintained some association with her described in secondary sources as a romantic one. What occupation he followed, where he resided at the time of her death, and what testimony, if any, he gave before the coroner's jury across the nearly 3 years of adjourned sessions, are not established with the detail available for Churcher and Verrill. His name persists in the case chiefly as one among several men whose lives had, at some point, intersected with Harriet Monckton's own, a fact the inquest was required to weigh without being able to translate it into a formal finding of responsibility. The verdict returned in 1846, wilful murder by some person or persons unknown, was not without precedent among the coroners' courts of Victorian England, though the length of the proceedings that produced it, extending across nearly 3 years of intermittent sessions, marked the case as unusual even by the standards of an era in which inquests could, on occasion, extend well beyond the days or weeks typical of most such proceedings. Comparable cases from the same decades in which a death was formally confirmed as murder without any individual ever being charged were recorded elsewhere in England during this period, arising from circumstances that shared with Harriet Monckton's case the same essential difficulty, a small community bound by close personal ties in which every plausible suspect was already known to every witness called to testify against him, and in which the ordinary distance a court might maintain between accuser and accused could scarcely be preserved. It was a pattern that left, in each such instance, a formal record of murder confirmed, and never resolved. The file closed only in the procedural sense that no further session of the inquest would be convened, while the substantive question it had been convened to answer remained exactly where it had stood at the outset. The physical setting of the case, the chapel, and the privy standing behind it, continued to serve the practical needs of the congregation for years after 1843, a detail that underscores the particular character of Harriet Monckton's death within the community that mourned her. Unlike a death occurring in a location associated with danger, a lonely road, a disreputable quarter of a larger town, hers had occurred within the grounds of the institution most closely associated in the minds of Bromley's nonconformist congregation, with safety, moral order, and the careful supervision of conduct. It was this incongruity a devout young teacher, found dead by poison on the ground of her own chapel, secretly carrying a child whose father was never identified, that gave the case its particular hold upon the town's imagination during the years the inquest remained open, and that has continued to give it a similar hold upon those who have encountered the surviving record in the years since. The coroner's jury, in returning its verdict of wilful murder by some person or persons unknown, closed the only proceeding the law of 1843 provided for the case, without closing the questions that had occupied Bromley for very nearly 3 years, and without providing any of the men whose names had been called before it, repeatedly, session after session, with either the vindication of a formal clearing or the resolution of a formal charge. The record of the Monckton family itself, thin as it remains on the particulars of Harriet's birth and upbringing, permits at least the observation that her surname was not an uncommon one in Kent during this period, and that the family into which she was born had established itself in Bromley with sufficient standing to be described, in what documentation survives, as respectable in the eyes of the town. This standing would have carried its own quiet expectations that a daughter of such a family conduct herself according to the moral standards prized by the chapel community she attended, that she maintain her position as a teacher without scandal, and that any private difficulty she encountered be resolved, so far as possible, away from public notice. The surviving record does not permit an account of how Harriet Monckton's own family responded to the discovery of her death, nor to the subsequent revelation of her pregnancy at the post-mortem examination, nor to the 3 years of testimony that followed as the inquest returned again and again to circumstances touching so closely upon their daughter's private life. Where earlier generations of Bromley residents might have spoken of these matters among themselves, no transcript of such private grief has come down as part of the formal record, and this account does not attempt to supply what the family itself may have felt across those repeated adjournments, the summonses to appear, the renewed questioning of persons they had known for years, and the eventual verdict that named a crime without naming a criminal. The clerk who recorded each session of testimony across the extended course of the inquest would have worked according to the standard practice of the period, setting down each witness's account in the first person as delivered under oath, a document then read back to the witness for confirmation and signed before the session's adjournment. It is this procedural discipline, repeated across what appears to have been a substantial number of separate hearings over nearly 3 years, that accounts for the survival of so much detail regarding the individuals connected with Harriet Monckton's death, even where the substance of that detail failed, in the end, to satisfy the standard of proof the law required before any name could be formally attached to the verdict of wilful murder. Each adjournment represented, in practical terms, a decision by the coroner that the evidence gathered to that point remained insufficient to conclude the matter, and each renewed session represented a fresh attempt to gather what earlier sessions had failed to produce, an effort that continued, by the measure of the surviving record, for very nearly 3 years before the coroner and his jury concluded that no further adjournment was likely to succeed where so many previous ones had not. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. That is where the record of the second case ends. We turn now to a third and final account, smaller still in its surviving detail, drawn from a different county and a different decade, concerning a household that believed itself secure because of who occupied it rather than where it stood. The question at its centre was never answered either, though for a time it appeared that it might be. The case of Martha Halliday begins in the parish of Kingswood, near Reigate, in the county of Surrey, in the year 1861. Kingswood in that period was a small rural parish on the North Downs, a scattering of cottages and farms clustered around a church and a rectory, several miles from the market town of Reigate, and within the broader orbit of the county town of Guildford. The parish had no industry of note. Its economy rested on agriculture, on the small trades that served an agricultural population, and on the presence of the church itself, which in a parish of this size was frequently among the largest and most substantial buildings for some distance in any direction. The rectory at Kingswood stood somewhat apart from the cluster of the village, a detached position that was common for clergy residences of the period, intended to afford the incumbent a measure of privacy and dignity befitting his office. A churchyard adjoined the church, and within or near that churchyard stood a small cottage occupied by the parish clerk and his wife. The year 1861 fell within the middle portion of the reign of Queen Victoria, a period in which rural Surrey remained largely untouched by the industrial expansion, transforming parts of the Midlands and the north of England. The railway had reached into parts of Surrey by this date, shortening the distance between London and towns such as Reigate, but a parish as small as Kingswood remained oriented around older patterns of life, the agricultural calendar, the rhythms of the parish church, and the close, largely known population, typical of small rural communities. Roads in the vicinity were unpaved and often poor, particularly in wet weather, and travel between Kingswood and the surrounding towns was undertaken on foot, on horseback, or by cart. Nightfall in such a parish brought near total darkness away from the few lit windows of inhabited houses, a condition that had considerable bearing on the events that were to unfold within the rectory walls. The parish clerk of Kingswood at this time was a man named William Halliday. The position of parish clerk was a recognised and respected office within the administration of an English parish church, historically responsible for assisting the incumbent clergyman in the conduct of services, maintaining certain parish records and performing a range of practical duties connected with the church and churchyard. It was not an office of high status in the manner of the clergy itself, but it carried with it a settled respectability, and those who held it were ordinarily long-established residents known to the whole parish. William Halliday's wife was named Martha Halliday. She was approximately 55 years of age at the time of the events described in this account. The surviving record does not establish the date or place of her birth, the names of her parents, or the circumstances of her earlier life, prior to her marriage and residence in Kingswood. This absence is not unusual for a woman of her station and period, whose life, in the ordinary course of things, would not have generated the kind of documentation that survives for the more prominent figures of her time. What the record does establish clearly and repeatedly is her position within the parish at the time of her death, her marriage to the parish clerk, and the trust placed in her by the rector of the parish. That trust took a specific and, in retrospect, consequential form. The rector of Kingswood at this date was the Reverend Samuel Barnard Taylor. In the early part of June 1861, Reverend Taylor was away from the parish, visiting the nearby town of Dorking, a journey of a few miles that would not have been considered unusual or remarkable for a clergyman of the period, whose duties frequently required travel within the surrounding district. In his absence, the rectory itself, a substantial house containing whatever furnishings, plate and possessions were customary to a clergyman's residence, stood without its principal occupant. It was Martha Halliday who had been engaged, or who had otherwise undertaken, to look after the rectory during this absence. The precise terms of this arrangement, whether it was a formal engagement with payment attached or an informal understanding arising from her husband's office and her own standing in the parish, are not established in the surviving record. What is established is that on the evening of Monday, the 10th of June, 1861, Martha Halliday was present at the rectory in this capacity, with the building otherwise unoccupied by its usual residents. Her husband, William Halliday, had been with her at the rectory for some part of that evening. Their own cottage, in or near the churchyard, stood at a distance later described as approximately 300 yards from the rectory itself, a distance that in a rural parish of this kind represented a short walk, but nonetheless placed a measurable interval between the two dwellings. At approximately 6 o'clock in the evening, William Halliday departed the rectory to return to his own cottage. This was, according to the record that survives, the last occasion on which he saw his wife alive. No account survives of any words exchanged between them at this parting beyond the ordinary business of a husband leaving his wife to her duties for the evening, nor would such an account be expected to survive for a couple of this position in a period that did not routinely record the private conversations of parish clerks and their wives. The surviving record does not establish, with any certainty, how the individuals who entered the rectory that night came to select it as a target, beyond the general facts of its situation. The rectory stood in a somewhat isolated position relative to the main body of the village, a common arrangement for clergy houses of the period, and its principal occupant, the rector, was known within the immediate vicinity to be away in Dorking. A substantial rectory, occupied by a clergyman, was, in the general understanding of the period, likely to contain plate, furnishings, and other possessions of some value, and a temporarily unoccupied clergy residence, guarded only by a caretaker rather than its owner, presented an opportunity of the kind that itinerant persons moving through a district might be alert to. Beyond these general circumstances, the record does not establish a specific chain of planning or decision-making on the part of whoever entered the rectory that night. What can be stated with confidence is that during the hours of darkness, on the night of the 10th of June, the rectory was entered, and that Martha Halliday, alone within it, was set upon by those who had entered. The manner of the attack, so far as the surviving record establishes it, involved the physical restraint of Martha Halliday by binding. She was bound at the hands and at the feet. A gag, described in the record as a stocking or sock, was forced into her mouth. A further article, described as a shirt or a handkerchief, was secured around her neck and the lower part of her face, evidently to reinforce the gag and prevent any outcry. The combined effect of this binding and gagging was to cause her death by suffocation. The cause of death, as established through the medical and coronial process that followed, was suffocation arising directly from the restraint applied to her. A bludgeon fashioned from beechwood was subsequently recovered at the scene of the crime, though the surviving record does not establish with certainty whether this implement was used to strike her, or whether it served some other purpose in the course of the burglary, such as a tool of intimidation, or one simply carried and later discarded. The established cause of her death remains suffocation, and this account does not assert that she was also struck, that detail not being confirmed in the sources upon which this account relies. No witness to the attack itself survives in the record. The rectory, standing apart from the main village and unoccupied by its principal resident, offered no immediate opportunity for an alarm to be raised or assistance to be summoned during the hours in which the attack took place. Martha Halliday remained within the rectory in the condition in which she had been left through the remaining hours of the night. On the following morning, Tuesday, the 11th of June, 1861, William Halliday returned to the rectory. It was he who discovered his wife. She was found lying upon the floor, still dressed in her night clothes, bound at the hands and feet, and gagged in the manner already described. The record does not preserve any account of William Halliday's words or actions in the moments immediately following this discovery, beyond the fact that the alarm was raised without delay. Given the setting, a clergyman's rectory, and the identity of the victim, the wife of the parish clerk engaged in its care, the discovery was treated from the outset as a matter demanding immediate and serious attention from the local authorities. Word of the discovery spread quickly through the small parish and into the surrounding district. Carried in the manner such news travelled in a rural community of this size by direct report from house to house and farm to farm in advance of any formal notice. The immediate response to the discovery reflected the seriousness with which a violent death in a clergyman's residence was regarded. Local constables and, in short order, county investigators were summoned to the rectory. The scene was examined, and it was in the course of this examination that two objects of particular significance were recovered. The first was the beechwood bludgeon already described. The second, and ultimately the more consequential, was a bundle of papers written in the German language. These papers were later described as resembling a form of continental service book or record of the kind issued to certain categories of workers or travellers on the continent, and they contain details of the career, the physical appearance, and the movements of a named individual. The presence of these papers at the scene of a burglary and killing in rural Surrey directed the immediate suspicion of the investigating authorities toward itinerant persons of German origin known to be passing through the district at that time, a suspicion that was to shape the entire subsequent course of the investigation. The investigation that followed proceeded with a diligence appropriate to the gravity of the case and the standing of the household in which the crime had occurred. Inquiries were made throughout the district concerning German itinerants who had recently passed through the vicinity of Kingswood, Reigate, and the surrounding parishes of the North Downs. Descriptions gathered from the papers found at the rectory were circulated among constables in the county, and reports were sought from lodging houses, public houses, and other places where a travelling labourer of foreign origin might have sought shelter or employment in the days preceding the 10th of June. This was not swift work. Surrey in 1861 possessed a constabulary of limited numbers relative to the ground it was required to cover, and the movement of itinerant workers through rural districts seeking agricultural labour or passing simply from one town to another was neither closely tracked nor easily reconstructed after the fact. Investigators were obliged to rely upon the recollection of innkeepers, farmers, and villagers who might have observed a stranger of foreign appearance in the days before the crime, recollections that were necessarily imprecise and required careful corroboration before they could be treated as reliable. Some 11 days elapsed between the discovery of the body and the next significant development in the case. On the 21st of June, 1861, a young man was taken into custody by police in connection with the inquiry. He gave his name, at the point of arrest, as Augustus Salzmann. He was a German national, and his manner and appearance were consistent with the descriptions that had been circulated among the constabulary following the discovery of the papers at the rectory. He was questioned closely regarding his movements in the days preceding the 10th of June and regarding his knowledge of the papers found at the scene of the crime. In the course of this questioning, it was established to the satisfaction of the investigating officers that the name he had first given was not his own. The man under arrest was identified and in due course acknowledged himself to be Johann Karl Franz, a native of Schandau in Germany. The service papers recovered at the rectory were found to correspond to the description and career of this same Johann Karl Franz, a correspondence that formed the central plank of the case subsequently brought against him. Franz was formally charged on the 1st of July 1861 with being concerned in the murder of Martha Halliday. He was brought before the magistrates at Reigate to answer this charge. The proceedings before the magistrates in a case of this kind served a specific procedural function within the criminal law of the period. They were not a trial in the fuller sense that would follow at a higher court, but a preliminary inquiry conducted before justices of the peace, intended to establish whether sufficient evidence existed to warrant sending the accused forward for trial at a higher tribunal. Witnesses were examined before the magistrates, the circumstances of the discovery were laid before the court, and the papers found at the rectory were produced and described in detail. Franz was represented at these early hearings, and the proceedings extended across a series of appearances, rather than being concluded in a single sitting, a pattern common in cases of this seriousness, where evidence continued to be gathered even as the preliminary hearings proceeded. A further and more extensive hearing took place on the 16th of July, 1861, at which the courtroom was reported to have been filled to capacity with members of the press and residents of the district, an indication of the degree of local interest the case had generated by that point. At the conclusion of these hearings, the magistrates determined that the evidence gathered was sufficient to commit Johann Karl Franz for trial, and he was accordingly remanded to await that trial at a higher court. The medical findings in the case, so far as they are established in the surviving record, were limited in their specificity, but clear in their central conclusion. Martha Halliday's death was determined to have resulted from suffocation, brought about by the binding of her hands and feet, and the gagging of her mouth with the stocking and the further article secured about her neck and face. The name of the physician who conducted the examination of her body is not preserved in the sources upon which this account relies, nor is there any indication in the surviving record of disagreement or inconsistency among those who examined her as to the cause of death. The finding of suffocation, arising from restraint rather than from a blow or a wound inflicted by a weapon, was accepted without recorded challenge throughout the subsequent proceedings, and it was upon this finding that the case against Franz, and the case that might have been brought against any other person, necessarily rested. The procedural steps customary in a case of sudden and violent death, including the convening of an inquest before the coroner for the district, would have followed the discovery of Martha Halliday's body according to the ordinary practice of the period. The surviving record places its principal emphasis upon the magistrates' hearings at Reigate rather than upon a separately detailed account of the coroner's proceedings, and the name of the coroner who presided, along with the precise wording of any verdict returned at an inquest is not established in the sources available for this account. What can be stated is that the progression from the discovery of the body, through police investigation, to the arrest and committal of Franz followed the recognised channels of English criminal procedure for a case of this gravity, and that the committal hearings at Reigate, culminating in the decision of the 16th of July, constituted the documented threshold between local inquiry and the formal trial that was to follow at a higher court. Following his committal, Johann Karl Franz was conveyed from Surrey to await trial at the Central Criminal Court in London, the tribunal before which the most serious criminal charges arising within its jurisdiction were heard. The interval between his committal at Reigate and the opening of his trial required the assembly of witnesses, the preparation of the case for the prosecution, and the arrangement of his defence. Franz was defended by the Honourable George Denman, a barrister then in the earlier years of a career that would in time lead him to the judicial bench. Denman's engagement in the case placed before the court an advocate of established ability, and the defence he mounted on behalf of his client was to prove decisive in the outcome that followed. The case presented against Franz rested principally upon the papers recovered at the rectory, papers that were shown to correspond in their detail to his own career and description, and upon the fact of his presence in the district in the period surrounding the crime. Against this, the defence advanced an account of Franz's own movements in the weeks preceding the 10th of June. According to this account, Franz had been travelling in the company of two other German nationals, described as sailors, named Wilhelm Gerstenberg and Adolf Krohn. It was said that these two men had spoken, in Franz's hearing, of an intention to rob a clergyman of means, and that the bundle of papers identifying Franz, papers of a personal and official character that he would ordinarily have kept upon his own person, had been lost to him or taken from him before the burglary at Kingswood took place. On this account, the presence of his papers at the scene of the crime was explained not by his own participation in the burglary, but by their having passed out of his possession and into the hands of others prior to the night in question. The trial proceeded over the course of several days, with witnesses called on behalf of the prosecution to establish the circumstances of the discovery at Kingswood, the recovery of the papers and the bludgeon, and the process by which Franz had come to be identified and arrested under an assumed name. Denman for the defence pressed upon the jury the absence of any direct evidence placing Franz within the rectory on the night of the killing, and set before them the account of Gerstenberg and Krohn as an alternative explanation consistent with the physical evidence recovered at the scene. The prosecution was not in a position to produce either Gerstenberg or Krohn before the court, nor to demonstrate through any other means that Franz himself, rather than these two named associates, had been present at the rectory on the night Martha Halliday was killed. The case, in its final form, turned upon whether the jury could be satisfied, upon the evidence as it stood, that the papers found at the scene proved the presence of the man to whom they belonged, or whether that presence remained upon the evidence no more than a matter of suspicion. Following the conclusion of the evidence and the addresses of counsel, the jury retired to consider their verdict. Their deliberation lasted approximately 1 hour. Upon their return, they delivered a verdict of not guilty. The courtroom, according to the accounts that survive of the proceedings, broke into applause at the announcement of the verdict, a public response to the clearing of Franz's name that was noted and remarked upon at the time. Franz was discharged from the dock, a free man. He returned in due course to Germany, and it is recorded that he wrote a letter of thanks to Denman for the conduct of his defence. Beyond this, the surviving record offers no further account of the remainder of his life. Gerstenberg and Krohn, the two men named by Franz as the true authors of the burglary and the killing that resulted from it, were never apprehended. No warrant against them is recorded as having succeeded in bringing either man before a court, and no further investigation into their whereabouts is documented in the sources upon which this account relies. The case, in its formal and legal sense, concluded with an acquittal. In every other sense, it remained exactly where it had stood on the morning William Halliday found his wife, lying bound upon the rectory floor. The case of Martha Halliday did not pass into the wider currents of Victorian criminal literature in the manner of some of the more notorious killings of the era. It generated no ballad, no popular pamphlet of the kind sold in the streets of London following a celebrated trial, and no dramatic adaptation for the stage. Its place in the historical record has rested, instead, upon more specialised forms of preservation. The case has been examined in works of true crime scholarship devoted to the lesser-known killings of the 19th century. Among them a study by the writer Jan Bonderson, whose survey of Victorian murder cases gave the Kingswood killing a place alongside other crimes of the period that similarly failed to reach a clear resolution. Bonderson's treatment of the case raised a question that the trial itself had left unanswered, a question that has since attached itself to the case as its principal point of continuing interest. That question concerned the verdict itself, and whether the acquittal of Franz reflected the true facts of what had occurred at the rectory on the night of the 10th of June. Bonderson's suggestion, advanced as an interpretation rather than as newly discovered evidence, was that Franz might not have been so entirely removed from the crime as the jury's verdict implied. The account of Gerstenberg and Crone, upon which the defence had rested its case, could not itself be tested before any court, since neither man was ever produced, examined, or required to answer for the allegations Franz had made against them. It remained possible, on this reading, that the account given by Franz of 2 absent associates and a set of papers lost or stolen before the burglary was constructed to explain away evidence that in fact pointed toward his own presence at the rectory. It remained equally possible that the account was substantially true, and that 2 men who were never found had left behind them a set of papers belonging to a companion who had himself played no part in the killing. The surviving record does not permit either possibility to be resolved with confidence. What can be said is that the doubt raised by later students of the case was doubt of a kind directed at a verdict already delivered, a matter of historical interpretation rather than a challenge mounted within the machinery of the law itself, since English criminal procedure afforded no mechanism by which an acquittal, once entered, could be reopened or revisited by a subsequent court. The case has also found a place in broader compilations of unresolved English homicides, appearing among the entries of lists devoted to killings from the middle decades of the 19th century, in which no person was ever convicted of the crime. Its inclusion in such compilations rests upon the same fact that has shaped every subsequent account of the killing, that a woman was bound, gagged, and left to suffocate in the rectory she had been trusted to look after, that a man was tried for the crime and acquitted within the space of an hour's deliberation, and that the 2 names he offered in his own defence were never brought before any tribunal to answer for what he alleged against them. Regional interest in the case has persisted longer than any national attention it received at the time, preserved in the local historical record of the district around Reigate and Kingswood, where the killing of a parish clerk's wife within the rectory she had been entrusted to guard remained, for those who kept the local record, a case remembered chiefly for the questions it left unresolved rather than for any answer it produced. The killing at Kingswood belonged to a period in which the presence of itinerant labourers from the continent moving through the counties of southern England was a matter of ordinary, if often uneasy, awareness among the settled populations of small rural parishes. Men of German origin, among others, travelled through districts such as this in search of agricultural work, seasonal employment, or simply passage from one part of the country to another, and their arrival in a village or parish was noted, discussed, and in many cases regarded with a wariness that owed as much to their unfamiliarity as to any specific conduct on their part. The rapid direction of suspicion toward a German itinerant following the discovery of the papers at the rectory reflected this broader temper of the period, in which a stranger of foreign speech and uncertain occupation found or reported in the vicinity of a serious crime was liable to become the immediate object of inquiry ahead of other lines of investigation that might otherwise have been pursued. The vulnerability exposed by the killing was not confined to the question of Franz's presence or absence in the district. It lay also in the arrangement by which a substantial clergy residence, standing apart from the body of its village and containing whatever plate and furnishings were customary to such a house, was left in the sole charge of a caretaker during the incumbent's absence, an arrangement common to parishes of this kind throughout rural England in the period, and one that offered a particular opportunity to those disposed to take advantage of it. Rectories and vicarages of the mid-19th century were frequently among the more substantial private dwellings in a rural parish, built at a scale reflecting the social position of the clergy rather than the ordinary means of the surrounding population, and their comparative isolation from neighbouring houses, intended to afford the incumbent quiet and privacy, left them without the immediate protection that closer proximity to other dwellings might have provided in the event of an intrusion during the hours of darkness. The path by which the case moved from the discovery of a body in a rural parish to a full trial at the Central Criminal Court in London illustrates the manner in which the criminal law of the period addressed offences of the gravest character, regardless of how small or remote the parish in which they occurred. A killing in a village the size of Kingswood was not tried by local justices sitting alone, nor concluded at the level of the county assizes in every instance, but could be, and in a case of this seriousness was committed forward through the local magistrates to the highest criminal court within the jurisdiction, there to be tried before a judge and jury under the same procedures that governed the most notorious London killings of the period. This channel, running from the parish constable through the county magistrate to the criminal courts of the capital, bound the smallest rural community to the same system of law that governed the city, and ensured that a case such as this one, however modest the surrounding parish, was tried with the full formality the law provided for an offence of this character. The Central Criminal Court before which Franz stood trial held its sittings at the Sessions House, adjoining Newgate Prison in the City of London, a building given over entirely to the administration of criminal justice for London and the surrounding counties, brought within its jurisdiction under the statute that had established it some 3 decades earlier. Prisoners committed from counties such as Surrey were conveyed to London to await the opening of the relevant sessions, of which several were held across the course of a year, each session lasting a number of days and disposing of a calendar of cases gathered from across the court's wide jurisdiction. The courtroom itself was arranged in the manner customary to the criminal courts of the period, the bench raised above the well of the court, the dock enclosed and set apart for the prisoner, and galleries above given over to those members of the public and the press who had secured admission to observe proceedings of particular interest. A case such as this one, involving a foreign national accused of a killing within a clergyman's rectory, was of a character likely to draw a full complement of spectators to those galleries, once word of the trial's opening had circulated among those who followed the reporting of the assize and sessional courts in the London press. The jury before whom Franz's case was laid consisted, in accordance with the practice of the period, of 12 men drawn from among the propertied residents qualified to serve in that capacity, householders and tradesmen of the kind, called upon routinely to sit in judgment in the criminal courts of London. Their task, once the evidence had been laid before them and the addresses of counsel concluded, was to weigh the correspondence between the papers found at the rectory and the man in the dock against the alternative account advanced on his behalf, an account resting upon 2 names, Gerstenberg and Crone, that could be spoken in court but could not be examined, cross-questioned, or made to answer for themselves before the same tribunal. It was this asymmetry between evidence that could be tested and an explanation that could not, that the 12 men were required to resolve within the space of their retirement, a space that in this instance extended to a single hour before they returned to deliver their finding to the court. The parish of Kingswood Once the trial in London had run its course and the verdict had been carried back by report into the Surrey countryside, was left to absorb an outcome that answered nothing of what its own residents had witnessed in the days immediately following the discovery at the rectory. The Reverend Samuel Barnard Taylor, who had been from home in Dorking on the night of the killing, returned to a parish in which the very building he was to occupy as his residence had become, within days, the scene of an inquiry that drew constables, magistrates, and eventually the attention of the London press to a village that had rarely before had occasion to appear in any newspaper account. He gave evidence in the course of the committal proceedings at Reigate, describing the arrangement by which the rectory had been left in Martha Halliday's care during his absence. Testimony that established for the court the ordinary and unremarkable nature of an arrangement that had, in the event, placed her alone within the house on the night she was killed. William Halliday continued to reside in the parish following the death of his wife, in the cottage near the churchyard that had been their home, and the surviving record offers no indication that his office as parish clerk was interrupted or altered by the events of that June. He had been the one to raise the alarm on the morning of the discovery, and he had been called upon in the course of the proceedings that followed to give his own account of the last hour he had spent with his wife before leaving her at the rectory the previous evening, an account that placed the final sighting of her alive at the hour of 6 o'clock and established, for the purposes of the investigation, the outer limits of the period during which the burglary and killing must have taken place. The rectory itself continued in its function as the residence of the parish's clergy, its walls carrying no permanent mark of the events of that single night beyond what remained in the memory of those who had lived through the weeks of investigation and trial that followed, a memory that within the small world of Kingswood parish persisted far longer than the brief national notice the case received in the London papers at the time of the Old Bailey proceedings. The case resurfaced in the pages of the press a decade after the trial had concluded, when a comparison was drawn in a newspaper report of 1871 between a killing then under investigation and the trial of Franz that had taken place 10 years before at the Central Criminal Court. The reference appeared in the Western Mail in a report dated the 20th of July of that year, which recalled the Kingswood proceedings as a point of comparison for readers considering the newer case then before the public, an indication that the trial of 1861, though it had produced no conviction and closed no file, had nonetheless lodged itself sufficiently in the memory of the press to be recalled by name a full decade later. Such a reference, brief as it was, points to the manner in which a case of this kind persisted not through any formal record maintained by the courts or the constabulary, but through the recollection of journalists and readers who had followed the original proceedings and who reached for it years afterward, as a point of reference when a broadly similar set of circumstances presented itself again. The Surrey Constabulary, for its part, retained no further active inquiry into the killing once the trial at the Central Criminal Court had concluded. No warrant is recorded as having been issued against Gerstenberg or Crone beyond whatever local inquiries may have followed immediately upon Franz's account of their movements, and no later record survives of either man being traced, questioned, or brought before any authority in connection with the events at Kingswood. The absence of any subsequent development in the case across the years, and then the decades that followed the trial, left the file in the same condition in which the jury's verdict had left it in July of 1861, a matter formally concluded so far as the criminal law could conclude it, and formally unresolved so far as the facts of what had occurred within the rectory on the night of the 10th of June were ever established beyond dispute. The church of Kingswood, within whose churchyard the Halliday cottage stood, was in 1861 a building of modest scale, in keeping with the size of the parish it served. Constructed of the local stone and flint, common to church building throughout this part of Surrey, with a small tower and a churchyard, enclosed by a low wall or hedge, marking its boundary from the surrounding fields and lanes. It was within this churchyard, or in close proximity to it, that William Halliday carried out the duties of his office, duties that in an ordinary year would have included the ringing of the bell before services, the maintenance of the church's registers, and the general oversight of the burial ground in which generations of the parish's inhabitants had been laid to rest. Martha Halliday's own burial, following the conclusion of the inquiry into her death, would in the ordinary course of parish practice have taken place within this same churchyard, among the graves of a community she'd lived within for the whole of her married life, though the surviving record does not preserve a specific account of the funeral itself or of those who attended it. The case has since been catalogued among the entries maintained in modern compilations of unresolved English homicides predating the 20th century, appearing within listings devoted specifically to killings in which no individual was ever convicted, a category that groups the Kingswood case alongside others scattered across the counties of England from the same broad period. Its entry within such a listing rests upon the bare essentials that the surviving record supports without dispute: the date of the crime, the location within the parish of Kingswood, the method of restraint that led to Martha Halliday's death, and the acquittal of the one man ever brought to trial in connection with it. Beyond these bare essentials, the compilers of such lists have not been able to add resolution where none exists, and the entry itself, spare as it is, reflects accurately the condition in which the case has remained since the jury delivered its verdict at the Central Criminal Court in the summer of 1861. George Denman's conduct of the defence at the Central Criminal Court marked one point within a legal career that extended a considerable distance beyond the Kingswood case. He continued in practice at the bar for a number of years, following the trial, appeared in a range of civil and criminal matters before the courts of England, and in time was raised to the judicial bench, sitting thereafter as a judge of the High Court, a distinction that placed him among those barristers of his generation whose early careers included the defence of prisoners, in cases that drew wide public notice before their later elevation to judicial office. The letter of thanks that Franz is recorded as having sent him following the acquittal represents one of the few personal traces to survive of the relationship between counsel and client. In this particular case, a brief and private acknowledgement of an advocacy that had, within the space of a single trial, secured the discharge of a man who might otherwise have faced the gravest penalty the law of the period could impose. The month in which Martha Halliday was killed fell within the early part of the agricultural summer in this part of Surrey, a season in which the fields surrounding Kingswood would have stood in the earlier stages of growth, ahead of the hay harvest that customarily followed in the weeks after midsummer. The daylight in the second week of June extended late into the evening, so that the hour of 6 o'clock, at which William Halliday parted from his wife, would have fallen well before the fall of full darkness, with the deeper night in which the burglary and killing took place, arriving only some hours later. The lanes and fields around the rectory, quiet by day, with the ordinary business of a farming parish, would have lain in near total darkness by the hour at which the intruders are understood to have entered the building, broken only by whatever light remained within the rectory itself from a candle or lamp left burning by its solitary occupant. The road connecting Kingswood to the town of Reigate, and beyond it to Dorking where the rector had gone, was in this period an unmetalled country road of the kind typical throughout the district, passable to foot travellers, to horses and to carts, but subject in wet weather to the mud that afflicted rural roads across Surrey before later improvements to their surface and drainage. It was along such roads that a stranger on foot, whether an itinerant labourer seeking work or a man passing through the district for reasons of his own, could move from parish to parish largely unremarked, stopping perhaps at a wayside inn or asking lodging at a farm in a manner that left little trace beyond the memory of those who happened to encounter him. The proximity of Kingswood to the larger town of Reigate meant that a traveller on foot could cover the distance between the two within the span of a single afternoon, a detail that bore directly upon the investigators' effort, in the days following the discovery, to trace the movements of any German itinerants who might have passed along this stretch of road in the period immediately before the 10th of June. The constables and county investigators who conducted this tracing work were obliged to rely upon description alone in the absence of any photographic record, since the systematic photographing of criminal suspects had not yet become an established practice within English police procedure at this date. A description of Franz, drawn from the papers recovered at the rectory and later confirmed against his own person following his arrest, would have been communicated between constabularies by written notice and by word passed along the ordinary channels of rural policing, a slower and less certain method than would become available to investigators in later decades, and one that placed correspondingly greater weight upon the recollection of witnesses who had seen a stranger of foreign appearance in the vicinity in the days before the killing. Reports gathered in this manner from lodging houses and public houses across the district would have been carried back to a central point of coordination among the Surrey Constabulary, most likely at Reigate itself, where the officers directing the inquiry could weigh one account against another before determining which lines of inquiry warranted further pursuit. A stranger who had taken a bed for a single night at a public house, paid in the ordinary coin of the realm, and departed the following morning without incident, might leave behind him nothing more than the recollection of a landlord or a servant, a recollection that could place him in the district at a given date, but could rarely establish with precision his movements in the hours before or after. It was against this uncertain body of local testimony, gathered laboriously across a rural district in the days following the 11th of June, that the identification of Franz under the name Salzmann was eventually achieved, an identification that rested finally not upon the recollection of any witness in the district, but upon the correspondence between his own person and the details preserved within the papers taken from the rectory. The German-speaking population passing through southern England in this period included men engaged in a range of occupations, agricultural labourers seeking seasonal work upon English farms, sailors between engagements at the ports along the southern coast, and others whose trades or reasons for travel are not established in the surviving record of this case. The description of Gerstenberg and Crone as sailors placed them within this broader category of continental labourers whose presence in the ports and along the roads connecting them to inland districts, such as Surrey, was an unremarkable feature of the period. Men who might pass through a county such as this in the course of travel between one port and another, or in search of work to sustain themselves, between engagements at sea, without their passage through any particular parish, drawing more than passing notice from those they encountered along the way. It was such passage through the ports that Franz himself was understood to have followed in the period before the killing, arriving in England as one among the many continental travellers who moved through the coastal towns of the south in the ordinary course of seeking work or passage, and making his way inland by the roads and paths available to a man travelling on foot with limited means. The account he gave of his association with Gerstenberg and Crone placed the three men together in the days preceding the 10th of June, travelling in company as men of similar background and language might naturally do when thrown together upon unfamiliar roads in a foreign country, sharing lodging where it could be found and such provisions as their means allowed. It was in the course of this shared travel, according to the account given in his defence, that Franz first heard the two sailors speak of the rectory at Kingswood and of the clergyman believed to occupy it, a conversation that Franz maintained he had witnessed without participating in whatever plan the two men subsequently carried into effect. The distinction the defence sought to establish before the jury was a narrow one, resting upon the difference between a man who had travelled in the company of others who later committed a crime, and a man who had himself entered the rectory and taken part in the events that led to Martha Halliday's death. It was a distinction that turned entirely upon matters that could not be independently verified since the only account of what had passed between the three men came from Franz himself, and no other witness was produced who could confirm or contradict the substance of what he described. The jury was thus required to weigh the physical fact of the papers found at the rectory, evidence that connected Franz directly to the scene of the crime, against an explanation of that connection that rested upon his own word alone, an explanation that the physical evidence could neither confirm nor disprove with certainty. The case of Martha Halliday was the last of these three cases to enter the historical record. The identity of the perpetrator was not established, no conviction followed. None was ever sought.